All right. All right. Pleasure to be here today. Thanks so much to the conference organizers for getting things for putting this all together. I have the task this morning of discussing the current clash. When I tried to figure out what to speak about, 12 minutes didn't seem quite to be able to capture everything. So let me just start by saying that I take the current clash to be framed by two broad trends in a post-employment division v. Smith world. The first one, I think the one familiar to us, is the conflict between religious liberty and anti-discrimination norms, things like Hosanna Tabor, Hobby Lobby litigation, state RFRAs, recent controversy in Arizona, recent controversy in Kansas, all these things, many of which, almost all of which, fall under the rubric of RFRAs and how they'll work out over the long term. I take that to be kind of one of the most salient pieces of the current clash. The other piece of it that I think gets a little bit less airtime is some of the moves for what I would describe as facially neutral laws, but that ultimately target, at least in my view, minority religious communities. And here I have in mind the continued growth of anti-Sharia bills in the United States. And also I would include in this some of the attempted circumcision bans in various municipalities around the United States, which have a very different dynamic, at least in my mind, than some of the kind of Hosanna Tabor, Hobby Lobby controversies. So trying to filter all this and what to talk about, I'm going to try and spend my next 10 minutes and 28 seconds discussing whether and under what circumstances should religious institutions receive a special protection from otherwise valid laws. That's kind of the piece of this that I'm going to try to take out from all these current trends and to see how exactly to sort this all out. And I'm going to try and advance what I've referred to in some of my writing as an implied consent framework and how this would kind of apply to some of the things we've chatted about. Just one quick caveat, this framework, it's a little complicated when you're talking about the First Amendment side and the RFRA side. I'll try to touch a little bit here and there on some of the differences, but obviously there's a strong connection to the extent that RFRA tracks pre-Smith First Amendment doctrine. I'll try to say a little bit about that now, but a little bit more hopefully in the question and answers. So what do I mean by an implied consent framework? Here I have in mind the Supreme Court in 1872 in Watson v. Jones. What I take to be its view on White is we have this doctrine known as church, quote-unquote, church autonomy. The kind of salient sentence is, all who unite themselves to such a body, referring to a church, do so with an implied consent to this government and are bound to submit to it. And my take on this is this idea was at its core voluntarist. It was this idea that individuals could join religious institutions, could do so via implied consent, and these religious institutions could become focal points where people would voluntarily join to pursue a shared conception of the good, certain shared values, shared principles, shared religious values, religious principles. And religious institutions allowed people to voluntarily join in this way so that they could lead sincere and authentic lives together as a group to pursue conceptions of faith and identity. That's kind of the short of it. There's obviously a lot more to say. But the idea here was that the religious institution, by authorizing it to make rules that dealt with the developing of religious doctrine, religious ideals, it helped people pursue their own individual conception of the good life, of the religious good life. It became this kind of institutional structure because of the way in which people pursue religion, very typically in collectivities. Okay, so I've said way too little about that, but I'd like to just say two consequences of this implied consent framework. First, at least to my mind, it means that the decisions of religious institutions, to the extent authorized by the implied consent of its members, the deference afforded those institutions shouldn't cover what the Supreme Court back in 1929 referred to as fraud, collusion, or arbitrariness. And the idea here is that if people impliedly consent to the authority of a religious institution, they give authority to pass good faith rulemaking, not decisions based on fraud or collusion. The standard in Gonzalez was pretty much discarded by the Supreme Court in the 1970s. I take this to be a mistake. If it's all about implied consent, then we have to ask, what types of decisions are we granting implied consent to? And so if you want to get like a practical implication of this in a Hosanna Tabor type case, if we're asking about pretext, my view is, yeah, we can interrogate pretext, and I don't think it draws us into resolving impermissible religious questions. What's another implication of implied consent? Well, when you ask who is a religious institution, obviously something that comes up pretty heavily in the Hobby Lobby litigation. My view is there aren't such things as religious institutions, but there are institutions whose nature allow us to presume the implied consent of their members. And so the questions you want to ask is, to what extent is an institution so obviously and openly engaged in religious activity that when somebody signs up with that institution, there we have good reason to presume they're implicitly consenting to the authority of that institution to pass rules and doctrine that relate to religious activities. And if you want to get a sense of how this might shake out in the Hobby Lobby litigation, so Mardell, kind of the silent plaintiff, which is this 35 Christian bookstores that exclusively sell Christian books, my view here is they probably have a pretty strong claim to being a religious institution. Hobby Lobby, on the other hand, sells generic arts and crafts. At the same time, they take out hundreds of ads that ask people to know Jesus is Lord and Savior. And to me, that's when you put yourself out there in that way, it raises the question as to what extent do people know that you're really a religious institution. Therefore, when they sign up with you, maybe as employees, do they know that they're trying to participate in some sort of religious endeavor? By contrast, Conestoga Wood Specialties, I haven't really seen anything in the record that would lead me to conclude that they manifest their religious aspirations in a way that we would want to presume, along the Watson v. Jones lines, that they are individuals are implicitly consenting to their authority. Okay, so that's kind of one piece of it, implied consent, and that tells us who might be a religious institution, who's a player in this game. Of course, being a player in this way, being a religious institution, doesn't end the inquiry. Then you have to kind of contend with the standard free exercise jurisprudence, and I'd like to say a little bit about that. So on the one hand, now that you're a religious institution, you still have to satisfy two more important criteria. One is you have to be sincere. My view is I think we do too little with the sincerity requirement. I think courts should do a lot more testing here. I think there are ways in which to consider the activities of religious institutions in light of their substantive religious doctrines. I'm committed to a view that I don't think there's really a problem for courts to engage in religious question inquiries, and so I think there's maybe a lot more we can do on the sincerity front to make sure that the institutions that are indeed religious institutions, that they're being sincere in the claims they make. By contrast, I have strong distaste for the idea that we can use the substantial burden inquiry, especially under RFRA, to really figure out the extent to which a particular imposition on religious doctrine is, to what extent it's religiously significant for a religious believer. That strikes me as a problem, as opposed to, of course, figuring out whether the financial side of things in fact imposes a religious burden. Here, to figure out how significant a particular doctrine is to somebody's religious worldview strikes me as something courts shouldn't engage in. On the flip side, the other side of this is, not only do I think we can do more with sincerity, I think we can do more with the compelling government interest standard. Some of Fred's presentation just alluded to this. Sometimes we call it it's impossible to satisfy. I think kind of those rhetorical moves have put a lot of pressure on the system. By saying that we can't satisfy strict scrutiny, I think it's led people to try to find other ways in which to sort out the good claims from the bad claims, so to speak. We've tried to figure out maybe too much inquiry into the substantial burden side of things in a variety of ways. And I think we should be candid that the compelling government interest standard is a really useful standard. It allows courts to take account of civil society and its view on various values at various points in time. It allows courts to take the temperature of the United States and figure out what we think is okay and what's not okay. It's very Lockean in a certain way. We allow religious institutions and religious actors to do as much as they need to do until we say you can do no more here. The values at stake from the perspective of civil society are simply too high. Put concretely, maybe it's the type of doctrine that can allow us to differentiate between Bob Jones cases and circumcision bans. In one case, a RFRA shouldn't help, and in one case, maybe it very well should help. Compelling government interest standards shouldn't be set so high that it doesn't do the work it can as a safety valve to make sure that we're sorting the right cases in the right places. In sum, if I were to try to summarize some of my views here, religious accommodation should be evaluated on the front end and the back end. On the front end, we should be asking questions like sincerity, implied consent, and on the back end, we should be asking questions about fraud, collusion, and arbitrariness, and we should be thinking about compelling government interests. In the middle of all this, there should be a strong, at least in my view, a strong amount of deference to religious institutions. We shouldn't be imposing artificial distinctions, at least in my view, on for-profit and not-for-profit. That's not the question we should be asking. We should be asking to what extent do individuals understand the institution they're signing up with and are doing so with the goal of joining for some sort of collective pursuit of a religious good. That's the real question we should be asking. And I don't think we should be parsing religious doctrine in order to determine how religiously significant a particular burden is for a religious believer. Some of the government's language and some of its lower court briefing saying that by definition for-profit institutions are not religious strikes me as the type of language that does strong dignitary harm to religious institutions. To tell a religious institution that you think you're religious, but in our view you're really not, as opposed to saying you're religious, but maybe we have a compelling government interest that says we simply can't accommodate here. These types of dignitary harms are obviously strongly at stake in all of this litigation, and the extent to which we can formulate the doctrine to take into account all types of dignitary harms, I think would be incredibly useful. Thanks.